"Sit down, or I'll have you removed." The words cut through the stale air of the Marbury County courthouse like a blade. The woman in the gray cardigan did not move. She stood in the gallery, leather folio pressed against her chest, watching. Behind the elevated bench, Judge Orville Bascom adjusted his glasses and leaned forward. "I said sit down." Still nothing. The woman's eyes moved from the judge to the young girl standing before the bench. Her niece, hands trembling at her sides, facing a charge that had somehow multiplied overnight. What Bascom did not know, what no one in that room could have guessed, was that he had just threatened a sitting judge of the United States Court of Appeals for the 11th Circuit. The next 14 months would cost him everything. But that was later. Right now, in this moment, Coretta Vance was just a black woman in a county courtroom who had committed the unforgivable sin of asking a question. The bailiff was already moving toward her. On the wall behind Bascom's chair, a plastic sign displayed words that would later appear in federal documents. "All persons appearing before this court have the right to be heard." Florida Rule of Judicial Administration 2.540. Coretta had read it twice when she walked in. She would read it again in the holding cell. The bailiff's hand closed around her arm. Somewhere behind her, Shayla Vance called out her aunt's name, voice cracking. The gavel came down, and the lock on Coretta's folio clicked shut, the only sound in the room that mattered. If you're new here, hit that subscribe button and turn on notifications. You won't want to miss what happens next. 48 hours earlier, Coretta Vance woke at 5:47 a.m., same as every other day for the past 31 years. The brick house on Sycamore Lane sat quiet in the pre-dawn gray. No husband, no children, no noise except the tick of the grandfather clock her father had left her and the soft hum of the refrigerator in the kitchen. She lay still for exactly 12 seconds, an old habit from her clerkship days, when the chief judge had told her that successful people controlled their mornings before their mornings controlled them. Then she rose, made the bed, hospital corners, smoothed the pillows until they sat parallel. In the kitchen, she filled the kettle with precisely enough water for 1 cup of coffee. While it heated, she opened the newspaper, the physical edition, delivered to her doorstep, and read the headlines without reaction. On her desk in the study, 3 pens sat in perfect parallel. A leather-bound notebook lay open to a fresh page, the date already written in the upper right corner in handwriting, so even it looked printed. This was Coretta Vance at 52. Measured, precise. A woman who had learned, through decades of practice, that control was not about power. It was about preparation. Her phone buzzed at 6:15 a.m. She looked at the screen. Shayla. For a moment, she did not answer. Her niece called often, usually about money, sometimes about advice, occasionally about nothing at all. Coretta loved the girl, but Shayla had a tendency toward drama that exhausted her. The phone buzzed again. Coretta picked up. "Coretta." Shayla's voice was strained. "I'm in trouble." "What kind of trouble?" "I got pulled over last week for running a yellow light. They gave me a ticket and I was going to pay it, but then I got this letter and now they're saying it's reckless driving and I have to go to court Monday and I don't understand what happened." Coretta set down her coffee cup. "Do you have the citation?" "Yes." "The letter?" "Yes." "Read me the charge exactly as it appears." There was rustling on the other end. Then Shayla's voice halting. "Violation of Florida Statute 316.192. Reckless driving, first-degree misdemeanor." Coretta was silent. A yellow light violation was a civil infraction. A $60 fine, maybe points on a license. Reckless driving was criminal, up to 90 days in jail for a first offense. "Who was the arresting officer?" Deputy Nash Garvey." "And the judge assigned to your case?" More rustling. "Orville Bascom." Coretta closed her eyes. She had never met Orville Bascom, but she knew the type. 20-plus years on the bench in a rural county, answering to no one, processing cases like cattle through a chute. "I'll come with you Monday," she said. "Really?" "Yes." "But don't you have work? I know you're busy with your government job." "I'll handle it. Text me the address and the time." She hung up before Shayla could thank her. Then she opened her laptop and began to research Marbury County Court. What she found did not surprise her, but it did make her pack extra pens. Monday morning arrived under a low gray sky. Coretta dressed carefully, brown slacks, gray cardigan, flat shoes, no jewelry, no designer bag, nothing that would mark her as anything other than what she intended to appear, a concerned aunt, present for moral support. She left her judicial ID in the safe, left her federal credentials in the drawer, took only her wallet, her phone, and the leather folio that had accompanied her through 3 decades of legal work. The drive to Marbury County took 90 minutes. The courthouse sat on the corner of Main and Crawford, a two-story building with water stains on the concrete and a flagpole that leaned slightly to the left. The American flag hung limp in the humid air. Coretta parked in the public lot and walked toward the entrance. The line at security was short, 3 people ahead of her, 2 young black men in ill-fitting suits, 1 older white woman clutching a stack of papers. The white woman went through the metal detector without a second glance. Then it was Coretta's turn. The bailiff, a thick-necked man with a name tag reading Hodge, looked her up and down. Bag on the belt, folio 2. She placed both items in the plastic bin. The machine beeped. Hodge held up his hand. Step aside. Coretta stepped aside. He opened her folio and flipped through it slowly, page by page, the blank paper, the pens, the small notepad tucked into the inside pocket. You a lawyer? No. Then why you got all this? I take notes. He continued flipping. Behind Coretta, the 2 young black men waited, eyes down. Who you here for? My niece, Shayla Vance. Traffic court. Yes. Hodge closed the folio, held it for a moment, then handed it back. Room 104, down the hall left. She took it. Thank you. He did not respond. The 2 young men were waved through without inspection. Coretta noted this, filed it away, walked on. Room 104 was small and hot. The air conditioning unit in the corner rattled and dripped water into a plastic bucket. The wooden pews, because that was what they were, pews salvaged from some demolished church, were packed with bodies, mostly black, mostly silent, mostly staring at the floor. At the front, behind an elevated bench that seemed too large for the room, sat Judge Orville Bascom. He was in his late 60s. White hair swept back from a high forehead. Half-moon glasses perched on a nose that looked like it had been broken at least once. He wore his robe like armor. To his left sat the court clerk, a woman in her 40s with bottle-blonde hair and a smile that appeared only when white attorneys approached the bench. Ramona Whitford. Coretta had found her name in the court records. To the right, the prosecutor's table. A young man with a receding hairline and an expensive watch sat shuffling papers. Sterling Jessup, assistant state attorney. Coretta found Shayla in the 3rd row. The girl looked terrified. Her hair was pulled back in a tight bun, and she wore a dress that was clearly borrowed, too long in the sleeves, too tight in the shoulders. Coretta sat beside her. Coretta. Shayla's voice was barely a whisper. I'm scared. Don't be. Coretta opened her folio. Just answer his questions. Don't volunteer anything. If you don't understand, ask for clarification. But what if... Vance! Ramona Whitford's voice cut through the room. Case number 2024-TR-04417. State of Florida versus Shayla Vance. Shayla's hands were shaking. Coretta squeezed them once. Brief, firm. Go! The girl stood and walked to the defendant's podium. Bascom looked up from his papers with the expression of a man who had already decided everything. Miss Vance, you're charged with reckless driving under Florida Statute 316.192. His voice was flat, bored. How do you plead? Shayla gripped the podium. Your Honor, I thought it was just a yellow light. The officer said, I didn't ask what the officer said. Bascom's gavel tapped once. I asked how you plead. Guilty, not guilty, or no contest. Pick one. But I don't understand how it went from a traffic ticket to... Miss Vance, the tap came harder. I don't have time for this. There are 40 cases behind you. Answer the question. Coretta watched her niece's shoulders curve inward. This was not justice. This was processing. She stood. Every eye in the room turned. Your Honor. Her voice was calm, level, caring without effort. May I address the court on behalf of my niece? Bascom's eyes narrowed behind his glasses. And you are? Coretta Vance. I'm her aunt. Are you an attorney? I'm here as family support. Then sit down. You have no standing here. Coretta did not sit. The sign on the wall behind you states that all persons appearing before this court have the right to be heard. I'm requesting clarification on the charge escalation from a civil infraction to a first-degree misdemeanor. The room went silent. Ramona Whitford's fingers froze above her keyboard. Sterling Jessup looked up from his papers. Bascom removed his glasses slowly, cleaned them with a cloth. Put them back on. Ma'am, I know the rules of my own courtroom. I don't need a civilian to recite them to me. His voice had dropped to something cold. Sit down, now, or I will hold you in contempt. Coretta's hand tightened on her folio. For a moment, just a moment, she considered revealing who she was, pulling out her judicial credentials, watching his face change. But that was not why she was here. She was here because Shayla deserved to be heard, because every person in this room deserved to be heard, and because the law meant nothing if the people who enforced it could silence anyone they chose. She sat. Bascom turned back to Shayla. I'll ask one more time. Guilty, not guilty, or no contest? Shayla's voice cracked. No contest. The gavel came down. Fine. $300 plus court costs. Driving school within 60 days. Bascom was already looking at the next file. Next case. Shayla stood frozen at the podium. Coretta rose, walked to her niece, and gently guided her toward the aisle. As they passed Sterling Jessup's table, the prosecutor looked up with a thin smile. Interesting aunt you've got there. Coretta met his eyes but said nothing. Some battles were won in courtrooms, others were won with patience. The hallway outside room 104 smelled of floor wax and something sour. Coretta led Shayla to a wooden bench near the water fountain. The girl was crying now, silent tears that streaked her makeup and dripped onto her borrowed dress. I don't understand. Shayla's voice was raw. I didn't do anything wrong. I just went through a yellow light. I know. And now I have to pay $300 and driving school? I can't afford that. I can barely afford... Listen to me. Coretta's voice cut through the panic. You can file a motion to withdraw your plea. Florida Rule of Criminal Procedure 3.170 gives you 10 days. I'll help you draft it tonight. Shayla looked up. Really? You can do that? I can help you do it. You'll file it yourself. Before Shayla could respond, a voice came from behind them. Ma'am, if you're not a licensed attorney, giving legal advice is a crime, just so you know. Coretta turned. Ramona Whitford stood 3 feet away, arms crossed, a manila folder pressed against her chest. I'm sharing public information with a family member. Coretta's voice remained even. That's not unauthorized practice of law under Florida Statute 454.23. Whitford's eyes narrowed. You got an answer for everything, huh? I have answers for questions I've prepared for. The clerk stepped closer, close enough that Coretta could smell her perfume, something cloying, artificial. Let me give you some advice. This isn't Tallahassee. This isn't Miami. This is Marbury County. And in Marbury County, people who ask too many questions tend to find that life gets complicated. Coretta tilted her head slightly. Is that a threat? It's an observation. The two women held each other's gaze. Then footsteps, heavy, deliberate, approached from the direction of the courtroom. Bailiff Hodge. There a problem here? Whitford smiled. This lady was disrupting court. Now she's out here playing lawyer. Hodge's hand moved to his belt. Not to his weapon, not yet, but to the handcuffs clipped beside it. Ma'am, you need to leave the building. Coretta did not move. On what grounds? On the grounds that I said so. That's not a legal justification for removal from a public courthouse. Hodge's jaw tightened. He was not used to this. People did not push back. People did not ask for justifications. People looked at his badge and his size and his authority, and they left. This woman was different, and he did not like it. I'm going to ask you one more time. His voice dropped low. Leave. Now. Coretta reached into her folio. Slowly. Deliberately. Both Hodge and Whitford tensed. She withdrew a pen and a small notepad. I'd like the case number for any incident report you're filing, and your badge number for my records. Hodge stared at her. No one had ever asked him that. Not once in 18 years. You don't get to make demands. Coretta wrote something in her notepad. I'm making a request. There's a difference. For a long moment, no one moved. Then Hodge stepped back. Just an inch. Barely perceptible. You've been warned. He turned and walked back toward the courtroom. Whitford lingered a moment longer. You're making a mistake. Then she was gone. Shayla clutched Coretta's arm. Coretta, maybe we should just go. Maybe... We'll go when I'm ready. Coretta closed her notepad. I want to observe a few more cases. But they just threatened you. Yes, they did. Coretta's eyes moved to the courtroom door. And I want to see exactly how often that happens to others. They returned to room 104. Coretta chose a seat in the back row, close to the exit, with a clear view of the bench, the clerk, and both attorneys' tables. Shayla sat beside her, still shaking. The afternoon docket continued, case after case, name after name. The pattern became undeniable. a young black man named Marcus Webb stood before the bench, charged with driving without a valid license. He tried to explain that his license had been suspended because he couldn't afford a previous fine. Bascom cut him off mid-sentence. "So you couldn't pay the fine, and you drove anyway. That's not a defense." Gavel. 60 days suspended. $200 fine. Next, a black woman in her 30s, charged with failure to appear for a previous traffic citation. She had a letter from her employer showing she had been at work during the scheduled hearing, a shift she couldn't miss without losing her job. Bascom did not read the letter. Failure to appear is failure to appear. $150. Next. A white man in a polo shirt approached the bench, charged with speeding, 17 miles over the limit. Bascom leaned back in his chair. "First offense?" "Yes, Your Honor." "Tell you what. Attend traffic school within 30 days. I'll dismiss this. Sound fair?" "Thank you, Your Honor." Next. Coretta wrote in her folio. Pattern. Differential treatment. Average hearing time for white defendants, 4+ minutes. Average for black defendants, under 2 minutes. No individual consideration. Assembly line justice. Her hand moved steadily across the page. She had seen courtrooms before, hundreds of them, from every angle. As a clerk, as an attorney, as a judge. But there was something particularly brazen about this one. Bascom did not even try to hide it. He simply did not believe anyone was watching. During the afternoon recess, Coretta approached the prosecutor's table. Sterling Jessup was packing files into a leather briefcase when she stopped in front of him. "Mr. Jessup." He looked up with the same thin smile from before. "The aunt. How can I help you?" "I'd like to request the discovery packet for case 2024-TR-04417. His smile did not waver. "Are you counsel of record?" "I'm assisting the defendant in filing a motion to withdraw her plea." "Then file a notice of appearance. Until you're officially on the case, I can't discuss it with you." He snapped the briefcase closed. "That's not me being difficult. That's procedure. I'm not asking you to discuss it. I'm asking for documents the defendant is entitled to under Florida Rule of Criminal Procedure 3.220. Jessup's smile thinned. "You're very persistent for someone who claims not to be a lawyer." "I never claimed that. You assumed." He studied her for a moment. Something shifted behind his eyes. Not respect exactly, but a flicker of caution. The discovery packet was sent to the defendant's address of record 2 weeks ago. He tucked the briefcase under his arm. If she didn't receive it, she should take that up with the Postal Service. He walked past her without another word. Coretta watched him go. Then she wrote in her folio, "Jessup, evasive. Claims discovery sent but no proof. Check mailing records." One viewer commented that they binged this entire channel in 2 days. If you're loving this story, smash that like button and let me know in the comments. She was walking back to her seat when a voice stopped her. "You're the aunt." Coretta turned. Deputy Nash Garvey stood in the doorway between the courtroom and the judge's chambers. He was tall, broad-shouldered, with the particular stillness of a man who had learned to use silence as intimidation. "I'm sorry?" "You're the aunt." The one who was talking back to Judge Bascom. His voice was casual, almost friendly. Coretta did not match his tone. "I asked a procedural question." Garvey smiled. "That's not how it looked from where I was standing." He walked toward her slowly, each step deliberate, measured. The hallway was empty now. Recess meant the bailiffs were outside smoking. The clerks were at lunch. The attorneys had retreated to their offices. It was just the two of them. "You should tell your niece to just pay the fine and move on." He stopped 3 feet away. Too close for comfort, too far for physical threat. "Making trouble in this courthouse doesn't end well for people like you." Coretta did not step back. "People like me?" "People who don't know their place." She let the silence stretch. Then she opened her folio and wrote, directly in front of him, the exact words he had just spoken. Date, time, location. Garvey watched her pen move. His smile disappeared. "What are you doing?" "Taking notes." "You can't." "I can. It's a public space. I'm documenting a conversation." She closed the folio. "Is there anything else, Deputy?" For a moment, just a moment, something ugly crossed his face. Then he stepped back. "Have a good day, ma'am." The word ma'am came out like a slur. "And remember what I said?" He walked away. Coretta stood in the empty hallway, folio pressed to her chest. She had faced worse than Nash Garvey, but she had never faced it alone, without her robe, without her title, without the weight of the institution at her back. This was what it felt like. This was what it always felt like. For everyone who walked into this courthouse without power. She found the complaints office on the second floor, or rather, she found the door that should have led to it. It was locked. A handwritten sign taped to the glass read, "Closed for renovation. Contact clerk's office for assistance." Coretta returned to the first floor. Ramona Whitford was back at her station, typing something into the court system. "Excuse me." Whitford looked up with an expression of practiced annoyance. "What?" "I'm looking for a complaint form regarding judicial conduct. We don't have those here. Florida Statute 43.291 requires that complaint procedures be posted in every courthouse. Where is that notice?" Whitford's typing did not slow. "I wouldn't know." "The Judicial Qualifications Commission. I'm busy." Whitford finally looked up, eyes flat. "If you want to complain about something, call Tallahassee, or Google it. I don't really care." She returned to her screen. Coretta stood there for a long moment. Then she turned and walked away, not because she was done, because she was just getting started. The afternoon session resumed at 1:30 p.m. Coretta returned to the gallery. Shayla had gone home, too shaken to stay, too exhausted to argue when Coretta insisted she could handle things alone. The seats had emptied somewhat. Most of the morning's defendants had been processed, their fines levied, their lives marginally worse. But the pattern continued. At 2:15 p.m., Bascom called the last case before public comment period. Coretta had learned about public comment during her research. Under Florida Rule of Judicial Administration 2.215, courts were required to allow brief public statements at the end of each session. Most judges ignored this requirement. Most citizens did not know it existed. Coretta knew. When Bascom finished with the final defendant, another black man, another suspended license, another fine that would cascade into more poverty, he reached for his gavel. "That concludes today's docket. Court is, Your Honor." Coretta was standing. Again. Bascom's face went through several expressions in rapid succession. Surprise, irritation, then something harder. "You again? I'd like to invoke the public comment period under Rule 2.215. Whitford looked up sharply. Hodge, who had been leaning against the wall, straightened. "What?" "Public comment. The court is required to allow members of the public to address matters of general concern before adjournment." Bascom removed his glasses. "I'm familiar with the rule." "Then may I proceed?" The silence stretched. Bascom could refuse. He had refused before. Coretta had found 2 complaints alleging exactly that during her research. Both had been dismissed without investigation. But this time, something was different. This time, someone was writing everything down. "You have 60 seconds. His voice was ice. Coretta nodded. "I'm formally requesting the case number for filing a complaint regarding the proceedings in case 2024-TR-04417. Specifically, I'm concerned about the escalation of charges without apparent justification, the denial of the defendant's request to understand the charges, and what appears to be a pattern of differential treatment." "That's enough." Bascom's hand came down on the bench, not the gavel, his palm flat and hard. "You're not here to make speeches. You're here to observe." He pointed at Hodge. "Bailiff, remove this woman. She's in contempt of court." Hodge moved fast. Coretta did not resist, but she did not go quietly. "I'm following the posted procedure, Your Honor. I'm exercising a right that exists in your own rules." Hodge's hand closed around her arm. His grip was not gentle. "Ma'am, you need to come with me." "I'm not resisting." Her voice remained level. "I would like this interaction recorded." "You don't get to decide what's recorded." He pulled. Her folio slipped from her grasp and hit the floor. Papers scattered. Her notes, her observations, the documentation of everything she had witnessed. She did not fight him. She simply repeated, clearly and calmly, "I am not resisting. I request a supervisor." Bascom's gavel came down. "Get her out of my courtroom." Hodge dragged her toward the door. Her feet scraped against the tile. The pages of her notes scattered in their wake. And from somewhere in the gallery, a phone captured everything. The hallway was empty except for Deputy Nash Garvey. He was waiting. Leaning against the wall, arms crossed, that same thin smile on his face. "Well, well." He pushed off the wall as Hodge dragged Coretta through the door. "Told you this wouldn't end well." Hodge released her arm, and Garvey stepped forward, already reaching for his handcuffs. "Ma'am, you're under arrest." Coretta's voice did not waver. "On what charge?" "Contempt of court. Obstruction of a judicial proceeding under Florida Statute 843.02. He spun her around, pressing her against the wall. "Hands behind your back." "I was following court procedure." "Hands behind your back," she complied. The handcuffs clicked shut, too tight, biting into her wrists. "I'd like to know the name of the supervisor on duty." Her voice was still calm, still measured. "And the case number for this arrest." Garvey leaned close. His breath was hot against her ear. "You'll get all that at booking, if you're lucky." He pulled her away from the wall, and that was when Shayla appeared. The girl had not gone home after all. She had been waiting in the parking lot, unable to leave, unable to stay. And now she stood at the end of the hallway, face ashen, watching her aunt being led away in handcuffs. "Coretta!" Coretta's eyes found her niece. "Convena?" Her voice was steady. "Go home. In my wallet, there's a number. Page 3, second from the top. Call it. Tell them exactly what you saw." Shayla was crying now. "But do it now, Shayla. Go." Garvey yanked Coretta forward. "Move." The last thing Coretta saw before the door closed was her niece, standing frozen in the hallway, tears streaming down her face. Then the door slammed shut, and the courthouse swallowed her whole. The patrol car smelled of disinfectant and something else, something older, darker. Garvey sat in the front, speaking into his radio. "Dispatch, this is Unit 47. I have one in custody from the courthouse. Female, black, approximately 50 years of age. Charge is contempt plus obstruction. Transporting to booking now." The radio crackled. "Copy, Unit 47. Booking is clear." Coretta sat in the back, hands cuffed behind her, watching the streets of Marbury County slide past the window. She had been in worse situations. She had presided over cases involving murder, corruption, the full spectrum of human cruelty. But she had never been on this side of the glass. The handcuffs were too tight. Her shoulders ached from the angle. The plastic seat was hard and cold, designed for discomfort. This was what it felt like. For everyone who had ever been arrested, guilty or innocent, violent or peaceful, this was what it felt like. The car turned onto a side street, then another, and then it stopped. They were not at the station. They were on a dead-end road, surrounded by empty lots and abandoned warehouses. Garvey turned off the engine. "Deputy?" Coretta's voice cut through the silence. "This is not the route to the booking facility." He did not respond. Instead, he got out of the car, walked around to her side, opened the door. "Step out. I am formally requesting that you resume transport to the booking facility." His hand closed around her arm and pulled. She stumbled out of the car, barely catching her balance on the cracked asphalt. "Deputy Garvey, I am documenting this deviation." "With what?" He gestured at her empty hands, her cuffed wrists. "Your notes are back at the courthouse. Your phone is in evidence. It's just you and me." He stepped closer. "You know what your problem is?" Coretta did not respond. "You think you're better than everyone else. Walking into that courtroom, asking questions, making demands." He grabbed her chin, forcing her to look at him. "You're not better. You're nothing. And the sooner you learn that, the easier this will go." "Remove your hand from my face," he laughed. "Or what?" And then he struck her. An open palm across the cheek. Not hard enough to leave a visible mark. He was too experienced for that. But hard enough to make her stumble. Coretta caught herself against the car. Her cheek burned. Her wrists screamed from the handcuffs. But her voice, when she spoke, was still steady. "You just assaulted a detainee." "I corrected someone who forgot their place." He straightened his uniform. "And who's going to believe you? A black woman arrested for contempt versus a decorated deputy?" He opened the car door again. "Get back in." She got in. He closed the door, walked back around, started the engine, and drove finally toward the booking facility. Coretta sat in the back, silent. Her cheek throbbed, her wrists bled, but her mind was already elsewhere, calculating, documenting. Every second of the 15-minute detour, every word he had said, every bruise that would bloom by morning. The Marbury County Detention Facility was a squat concrete building with barred windows and a parking lot full of patrol cars. Garvey pulled into the receiving bay and handed Coretta off to a processing officer, a woman named Denise Mobley, according to her name tag. "What's the charge?" "Contempt, obstruction, standard courthouse troublemaker." Garvey was already walking away. "Have fun with her." Mobley looked at Coretta. Really looked. Something in her expression flickered. Not quite recognition, but curiosity. "Come with me." She led Coretta through the intake process. Fingerprints, photographs, personal effects cataloged and bagged, wallet, phone, the wedding ring she still wore even though her husband had been dead for 11 years. Throughout it all, Coretta remained silent. Mobley noticed. "You're very calm." She typed something into the computer. "For someone who just got arrested for contempt. I've learned that calm is more useful than panic. That's an unusual perspective." "It's a practiced one." Mobley finished typing, looked up. "What do you do?" "For work, I mean." Coretta met her eyes. "I work for the government." A beat passed. Mobley did not ask which branch, did not ask which department, did not ask any of the questions that might have led to answers Coretta was not yet ready to give. Instead, she nodded. "If you need anything," she lowered her voice, "let me know." It was not much, but it was something. The holding cell was 8 feet by 10 feet. Concrete walls, metal bench, stainless steel toilet bolted to the floor. Coretta sat on the bench, hands finally free, wrists raw and bleeding. She had been in courthouses across 11 states. She had sat on panels that decided questions of constitutional law, that reviewed death penalty appeals, that shaped the fabric of American jurisprudence. And now she was in a county holding cell, arrested for asking a question. She closed her eyes, breathed, and began to wait. This story has 3 million views on our channel. If you want to see more content like this, subscribe and drop a comment below. 7 hours later, the door opened. Officer Mobley stood in the frame. "You're being released." Coretta looked up. "On what basis?" "Own recognizance. Charges pending review." Mobley handed her a manila envelope, her personal effects. "There's a car waiting for you outside." "What car?" Mobley hesitated. "I don't know, but whoever sent it, they have clearance I've never seen before." Coretta opened the envelope. Her wallet, her phone, her ring. She slipped the ring back on her finger. "Thank you, Officer Mobley." "Ma'am." Mobley's voice dropped even lower. "Whatever happens next, I hope it's enough." Coretta looked at her. For the first time since her arrest, something softened in her expression. "It will be." The sedan was black, government issue, parked in the visitor lot with its engine running. Coretta walked toward it slowly. Her body ached. Her wrists throbbed. The place where Garvey had struck her had bloomed into a dull purple shadow beneath her eye. The driver's door opened. A man in a dark suit stepped out. "Ms. Vance?" She stopped. "Who are you?" "I'm from the 11th Circuit Inspector General's office." He opened the rear door. "They're expecting you in Atlanta." Coretta did not move. "How did you know I was here?" The driver almost smiled. "Your niece called the number you gave her. 3rd page, 2nd from the top." He gestured toward the open door. "She's very thorough, like someone else I could mention." For the first time in hours, Coretta felt something loosen in her chest. Shayla had done it. She got into the car. The drive to Atlanta took 3 hours. Coretta sat in the back, watching the landscape change, from rural pine forest to suburban sprawl to the glittering skyline of the city. Her phone had been returned to her, but she did not use it. There would be time for calls later. For now, she needed to think, to process, to decide what came next. The Byron White Federal Building rose 17 stories above Peachtree Street. The driver pulled into the underground garage and escorted Coretta to a private elevator. They rose in silence. The doors opened onto a corridor lined with portraits, former chief judges of the 11th Circuit, their faces stern and judicial. Coretta recognized several of them. She had clerked for one. She had ruled against another. At the end of the corridor, a door stood open. The driver gestured. "They're waiting." Coretta walked forward, into the conference room, and stopped. On the polished table sat 3 items: a gold-plated badge, a federal identification card, and an official portrait. The portrait showed Coretta Vance in her judicial robes, standing before an American flag. 3 people sat at the table: the Inspector General, the Deputy Chief Judge, and a woman whose face Coretta recognized from news broadcasts, the head of the Department of Justice Civil Rights Division. The Inspector General spoke first. "Judge Vance." The word hung in the air. Judge. Not ma'am, not civilian, not troublemaker. Judge. "We received the call from your niece 6 hours ago. The 11th Circuit Chief Judge has been notified. So has the Attorney General." Coretta looked at her badge, her ID, her portrait, artifacts of a life that, for the past 12 hours, she had deliberately set aside. "I wasn't acting in my official capacity." Her voice was quiet. "I was there as a private citizen, as an aunt." The DOJ representative leaned forward. "That's precisely what makes this more serious, Your Honor." She slid a folder across the table. A sitting federal circuit judge was arrested for contempt by a county court for asking a question. Coretta opened the folder. Inside were documents, transcripts, incident reports, and something that made her breath catch. A photograph of her face, taken at booking. The bruise beneath her eye was darker in the harsh flash. "We obtained this from the detention facility 2 hours ago." The Inspector General's voice was grim. "Along with testimony from Officer Mobley regarding a 15-minute gap in transport time." Coretta closed the folder. "What happens now?" The DOJ representative smiled, but it was not a kind smile. It was the smile of someone who had been waiting for this moment for a very long time. "Now, Your Honor, we burn it down." Coretta sat in the conference room long after the others had left. The badge gleamed under the fluorescent lights. Her badge, her identity. She had spent 31 years building this career. 31 years of early mornings and late nights, of cases won and cases lost, of decisions that shaped lives she would never meet. And in one afternoon, in one county courtroom, she had been reminded of something she had almost forgotten. The law was not just words on paper. It was not just precedents and procedures. It was power. And power, unchecked, could crush anyone. Even her. She picked up her phone, dialed a number from memory. "Hello?" Shayla's voice was raw. She had been crying. "Con, oi." Coretta's voice was soft. "Co Atlanta. Co Antoine. Co Coretta, I was so scared. I didn't know what to do. I just called the number like you said, and then these people started asking questions, and you did exactly right. But what happened? Why did they arrest you? Are you okay?" Coretta looked at the bruise in her reflection on the polished table. "I'm okay. And what happened?" She paused. "What happened is going to change a lot of things. I don't understand." "You will." Coretta closed her eyes. "Get some sleep, Con. I'll explain everything tomorrow." She hung up. Then she opened the folder again and began to read. The documents told a story. Not the story Marbury County wanted told. Not the story Judge Bascom had spent 23 years carefully constructing. A different story. 47 complaints filed against Bascom since 2019. 43 dismissed without investigation. 4 receiving nothing more than informal advisement. All 47 complainants were people of color. Statistical analysis of his docket over 5 years. 71% of defendants were black, despite the county's population being only 43% black. Average hearing time for white defendants, 4 minutes and 12 seconds. Average for black defendants, 1 minute and 47 seconds. 14 allegations of inappropriate conduct by Bailiff Hodge. 6 complaints about Clerk Whitford's discriminatory treatment. 3 formal accusations against Deputy Garvey for excessive force during courthouse arrests. All dismissed, all buried, all forgotten, until now. Coretta closed the folder. She thought about Marcus Webb, the young man with the suspended license, trying to get to work, punished for poverty. She thought about every face in that gallery, every person who had stood before Bascom and been processed like cattle. She thought about herself, handcuffed and humiliated, slapped on a deserted road by a man who believed no one would ever hold him accountable. And she thought about Shayla, sweet, scared Shayla, who had only wanted to understand why a yellow light had turned into a criminal charge. Coretta picked up her pen and began to write. 3 weeks later, Lenora Fitch arrived in Marbury County, investigator for the Florida Judicial Qualifications Commission, 20 years of experience, a reputation for thoroughness that bordered on obsessive. She carried a briefcase containing 2 inches of documentation. She carried subpoenas for court records, bodycam footage, and personnel files. And she carried a mandate from the DOJ Civil Rights Division to determine whether the Marbury County Courthouse had engaged in a pattern or practice of violating citizens' constitutional rights. She did not come alone. Behind her, in a caravan of federal vehicles, came auditors, statisticians, and attorneys. They spread through the courthouse like water finding cracks. They pulled records, interviewed witnesses, examined every complaint that had ever been filed and dismissed, and they found what Coretta already knew, that Marbury County Court was not a courthouse. It was a machine designed to extract money from the poor, to silence the inconvenient, and to protect the powerful at all costs. The machine had been running for 23 years. It was about to stop. But that was not the twist. The twist came on Lenora Fitch's 3rd day in Marbury County. She was reviewing body cam footage from Garvey's arrest of Coretta when she noticed something. A gap. 10 minutes and 15 seconds. From 3:33:02 p.m. to 3:43:17 p.m. The timestamp jumped. The footage cut. And when it resumed, Coretta was already in the patrol car, her face bearing a bruise that had not been there before. Fitch pulled the IT report. Camera malfunction, battery issue, no footage available for this interval. But Fitch had been doing this job for 20 years. She knew what a battery malfunction looked like, and this was not it. This was a manual deactivation. Someone had turned off the camera, on purpose, during the exact window when something happened that left a federal judge with a bruise on her face. Fitch made a note. Then she pulled the communication logs for that afternoon and found something else. An email, sent at 2:47 p.m. on April 14th, the day before Coretta's arrest, from a redacted address to Judge Orville Bascom. Subject line, tomorrow's docket. Most of the email was blacked out, but one sentence remained visible. If she shows up again, handle it. Someone had known Coretta was coming. Someone had warned Bascom. Someone had wanted her handled. Fitch closed her laptop. This was not just about one corrupt judge. This was bigger. Much bigger. The documents arrived at Lenora Fitch's hotel room in waves. First came the court transcripts, 17 boxes delivered by a federal courier who required 3 signatures and a thumbprint before releasing them. Then came the personnel files, heavily redacted, fought over for 2 weeks before a federal judge in Jacksonville ordered their release. Then came the bodycam archives, the 911 logs, the internal memoranda, the complaint files that had been buried so deep they required a forensic data specialist to recover them from the county's aging server system. Fitch spread them across every surface in the room. The bed disappeared under manila folders. The desk vanished beneath stacks of printed emails. The floor became a maze of cardboard boxes, each one labeled with dates and case numbers and the names of people who had been silenced for decades. She worked 18-hour days. She subsisted on coffee and vending machine sandwiches. She spoke to no one except her team and, occasionally, the DOJ attorneys who called from Washington with questions that grew more urgent by the week. And slowly, piece by piece, she assembled the picture. Marbury County Court had not simply been negligent. It had not simply been biased. It had been designed, deliberately, systematically, over more than 2 decades, to function as a revenue extraction machine that targeted the county's most vulnerable residents. The pattern was elegant in its cruelty. Minor traffic infractions were routinely elevated to criminal charges, generating higher fines and court costs. Defendants who could not pay were jailed, generating per diem payments from the state. Those who challenged their charges were held in contempt, generating additional fines and creating criminal records that followed them for life. The system fed on poverty, and poverty in Marbury County had a color. Fitch documented everything. She cross-referenced case numbers with demographic data. She mapped the flow of money from defendants' pockets to county coffers. She traced the relationships between court officials, local politicians, and the private companies that profited from the county's aggressive enforcement. And at the center of it all, she found Orville Bascom, 23 years on the bench, over 40,000 cases adjudicated, a conviction rate that exceeded 97%, and a complaint file that should have ended his career a dozen times over, if anyone had bothered to read it. 6 weeks after Coretta Vance's arrest, Fitch requested a formal interview. Not with Bascom. His attorneys had already filed motions to quash any direct questioning. Not with Hodge or Whitford. They had lawyered up within days of the federal investigation's announcement, but with someone else. Someone whose name appeared in the margins of the story. Someone who had been watching for years. Marcus Webb lived in a single-wide trailer on the outskirts of Marbury County. The address was listed in court records from his case. The suspended license, the 60-day sentence, the $200 fine he was still paying off in $20 monthly installments. Fitch knocked on the aluminum door at 9 a.m. on a Tuesday. A young black man answered, late 20s, thin, eyes that had seen too much disappointment to trust easily. Mr. Webb. Who's asking? Fitch showed her credentials. Lenora Fitch, Florida Judicial Qualifications Commission. I'm investigating Judge Orville Bascom. Webb's expression did not change. Finally, he stepped aside and let her in. The trailer was clean but sparse. A couch with a blanket folded over one arm. A television that looked older than Webb himself. A kitchen table with 2 chairs, one of which had a broken leg propped up with a phone book. Webb sat in the good chair. Fitch took the broken one. I've been waiting for this. Webb's voice was quiet. For years, watching people go through that courthouse, getting chewed up, coming out worse than they went in. And nobody cared. Nobody ever cared. Tell me about your case, he laughed, a short, bitter sound. My case? That's what you want to know about? Not the hundreds of others I watched? Not the woman who lost her job because Bascom wouldn't reschedule her hearing? Not the kid who got 90 days for a broken taillight? I want to know about all of it, but I need to start somewhere. Webb looked at her for a long moment. Then he began to talk. His story was not unusual. That was the tragedy of it. He had been driving to work, a warehouse job, 40 minutes each way, no public transportation in Marbury County. His license had been suspended 6 months earlier for unpaid parking tickets. He could not afford to pay them off. He could not afford to miss work. So he drove. He was pulled over by Deputy Nash Garvey at 7:15 a.m. on a Wednesday. He knew. Webb's hands tightened on the arms of his chair. He knew exactly who I was. He'd pulled me over twice before, let me go with warnings both times. But that day, something was different. He was smiling, like he was enjoying it. Did he say anything? He said, "Third time's the charm, Marcus. Guess your luck ran out." Garvey had arrested him on the spot, impounded his car, a 2003 Honda Civic that had belonged to his grandmother, charged him with driving on a suspended license, a second-degree misdemeanor. By the time Webb's case reached Bascom's courtroom, the charges had mysteriously multiplied. The original citation mentioned nothing about speeding, but the formal charge sheet included reckless driving, a first-degree misdemeanor that carried up to a year in jail. Webb tried to contest it. Bascom gave him 60 seconds. Then the gavel came down. 60 days suspended, $200 fine, next case. I tried to explain. Webb's voice cracked. I tried to tell him I was just going to work, that I couldn't afford, that I had no other way to... He stopped, breathed. He didn't even look at me, just waved his hand like I was a fly, like I wasn't even human. Fitch wrote in her notebook, "Mr. Webb, I need to ask you something important. On the day you were in court, the day you were sentenced, do you remember seeing anyone else speak up? Anyone who tried to challenge the judge?" Webb's expression shifted. "You mean the woman." "What woman?" "The one in the gray sweater, older, calm." She stood up and started asking questions, and Bascom, I've never seen him like that. He got angry, really angry. Told the bailiff to remove her. "Did you see what happened after?" "I saw them drag her out." Webb's jaw tightened. "I saw Garvey waiting in the hallway, and I saw her get arrested. For nothing, for asking the same questions I wanted to ask but was too scared to." He looked at Fitch. "That's when I knew." "Knew what?" "That the system wasn't broken." His voice was flat. It was working exactly the way they wanted it to. If you're still watching, drop a comment and tell me what you think should happen to Judge Bascom. Your engagement helps this channel grow. Fitch's investigation expanded. She interviewed 37 former defendants over the next 2 weeks. Their stories varied in detail, but shared the same core elements: charges that escalated without explanation, hearings that lasted less than 2 minutes, fines that spiraled into debt that followed them for years. 12 of them had been arrested for contempt after attempting to speak in their own defense. 9 had been physically removed from the courtroom by Bailiff Hodge. 4 had reported being threatened or intimidated by Deputy Garvey. All of them were black. Fitch compiled the interviews into a preliminary report and sent it to the DOJ. The response came within 48 hours. The email was brief and formal. From DOJ Civil Rights Division to L. Fitch, Florida JQCRE, Marbury County Investigation, Authorization Expansion Investigator. Fitch, based on your preliminary findings, the Department of Justice is formally expanding its investigation of Marbury County Court to include potential pattern or practice violations under 42 U.S.C. Paragraph 14,141. A team of federal investigators will arrive in Marbury County within 7 days to assist with document review and witness interviews. Additionally, we are issuing preservation orders for all electronic communications involving Judge Orville Bascom, Bailiff Terrell Hodge, Clerk Ramona Whitford, and Deputy Nash Garvey for the period of January 2019 to present. Please coordinate with the U.S. Attorney's Office for the Northern District of Florida regarding logistics. The expansion changed everything. State investigations could be stonewalled, delayed, buried in procedural challenges. Federal investigations could not. Within a week, the team from Washington arrived. 6 attorneys, 4 forensic accountants, 2 data analysts, a specialist in law enforcement misconduct who had helped dismantle police departments in Ferguson, Baltimore, and Chicago. They set up operations in a rented office building 3 blocks from the courthouse. They worked in shifts, day and night, weekdays and weekends, and they began to find things that even Fitch had missed. The email was the first major discovery. Fitch had found the fragment, "If she shows up again, handle it," during her initial review. But the full chain had been encrypted, stored on a private server that the county IT department claimed to know nothing about. It took the federal team 6 days to crack it. When they did, they found a conversation that stretched back 3 years. The sender's address had been scrubbed from the metadata. but the content told its own story. November 12, 2021. Traffic revenue is down 15% from last quarter. The Commission is asking questions. We need numbers. November 14, 2021. Understood. Will adjust enforcement priorities. March 8, 2022. The new prosecutor is pushing back on charge escalations. He wants documentation. March 9, 2022. I'll speak to him. He'll understand. August 22, 2023. We have a problem. Someone filed a complaint with the state bar about Jessup's discovery practices. August 23, 2023. Handled. Complaint withdrawn. And then, April 14, 2024. One day before Coretta Vance walked into the courthouse. There's a woman asking questions about the Vance case. Older, black, showed up at the clerk's office requesting complaint forms. April 14, 2024. Reply, 47 minutes later. If she shows up again, handle it. Fitch stared at the printout. Someone had known. Someone had been watching. Someone had given the order before Coretta Vance ever stood up in that courtroom. The question was, who? The sender's identity remained hidden behind layers of encryption and burner accounts. But the trail did not end there. The forensic team traced the server to a hosting company in Jacksonville. The hosting company's records showed payments from a shell corporation registered in Delaware. The shell corporation's registered agent was a law firm that specialized in political consulting, and the law firm's client list, obtained through a federal subpoena that took 3 judges and 2 appeals to enforce, included one name that made Fitch drop her coffee cup. State Representative Warren Delacroix, chair of the Florida House Judiciary Committee, the man who controlled judicial appointments for 3 counties, including Marbury. The connection was circumstantial. Delacroix's involvement could not be proven, not yet, not with the evidence they had. But it explained things. It explained why complaints against Bascom had been dismissed for 23 years. It explained why the county's revenue enhancement practices had never attracted state scrutiny. It explained why everyone in the courthouse seemed to believe they were untouchable. Because they had been, until now. 3 months after the federal investigation began, the DOJ issued its preliminary findings. The press release was 12 pages long. Fitch read it in her hotel room, coffee growing cold beside her. Department of Justice. Civil Rights Division for Immediate Release Investigation finds pattern of civil rights violations in Marbury County, Florida. Court System, Washington. The Department of Justice announced today that its investigation of the Marbury County court system has found reasonable cause to believe that county officials have engaged in a pattern or practice of conduct that deprives persons of rights, privileges, or immunities secured by the Constitution and laws of the United States. Key findings include discriminatory enforcement. African American defendants were significantly more likely to face charge escalations, receive harsher sentences, and be held in contempt for courtroom behavior than white defendants with similar case profiles. Due process violations. Defendants were routinely denied the opportunity to understand charges against them, to present evidence, or to speak in their own defense. Excessive fines and fees. The court system imposed fines and fees that were grossly disproportionate to the offenses charged, creating a cycle of debt and incarceration that disproportionately affected low-income residents. Retaliation. Individuals who attempted to file complaints or challenge court procedures faced arrest, intimidation, and physical harm. The department has notified Marbury County officials that it intends to seek a consent decree requiring comprehensive reforms to court operations, training, and oversight. Fitch set down the press release. It was happening. After years of silence, after decades of impunity, the system was finally being held accountable. But she knew better than to celebrate. Consent decrees were negotiated, not imposed, and negotiations meant compromise. The next 6 months were a war of attrition. Marbury County hired 3 law firms to fight the federal intervention. They filed motions to dismiss, motions to limit discovery, motions to exclude evidence, motions to disqualify investigators. All were denied. But they succeeded in one thing. They delayed. Every week of delay was another week that Bascom remained on the bench, another week that Hodge patrolled the courthouse, another week that the machine continued to grind. Fitch documented new cases as they occurred. A single mother arrested for asking about a payment plan, a teenager held in contempt for crying during his hearing, an elderly man jailed for 3 days because he could not afford a $75 fine. The pattern continued, but now at least someone was watching. We're about to get to the part everyone's been waiting for. Make sure you're subscribed so you don't miss it. The administrative hearing was scheduled for November 12, 2024, 7 months after Coretta Vance's arrest. The venue was the Florida Judicial Qualifications Commission's hearing room in Tallahassee, a wood-paneled chamber designed to project gravity and tradition. Judge Orville Bascom, sat at the respondent's table, flanked by two attorneys in matching gray suits. His face was a mask of controlled outrage. 23 years on the bench, and now he was the one being judged. The irony was not lost on him, or on anyone else in the room. The panel consisted of 5 members, 2 circuit court judges, 1 county court judge, 1 attorney, and 1 non-lawyer citizen. They sat at an elevated bench, reviewing documents, occasionally whispering to one another. Lenora Fitch sat at the prosecutor's table. She had been designated as the JQC's presenting officer for the hearing, the person responsible for laying out the case against Bascom. Behind her, in the gallery, sat a single row of observers. Marcus Webb was there. He had driven 4 hours to watch. Officer Denise Mobley was there. She had taken a personal day. Shayla Vance was there. She had not missed a single day of the proceedings. And in the back row, wearing the same gray cardigan she had worn 7 months earlier, sat a woman whose presence made Bascom's attorneys visibly uncomfortable. Coretta Vance had not been called as a witness. On advice from the 11th Circuit's Ethics Council, she had declined to participate formally in the proceedings, but no one could stop her from observing. She sat with her leather folio in her lap, taking notes, just as she had done on the day this all began. The hearing opened with formalities. The panel chair, a retired circuit judge named Helen Forsyth, read the charges aloud. The respondent, Orville Raymond Bascom, is charged with violations of Canon 2 and Canon 3 of the Florida Code of Judicial Conduct, specifically, failure to perform judicial duties impartially, failure to accord every person who has a legal interest the right to be heard, conduct prejudicial to the administration of justice, and willful misconduct in office. Bascom's lead attorney stood. The respondent denies all charges and requests that this panel recognize his 23 years of distinguished service to Marbury County. Forsyth's expression did not change. Noted. Ms. Fitch, you may proceed. Fitch began with the statistics. She projected charts onto the screen behind her, graphs showing conviction rates by race, average hearing times by race, charge escalation patterns by race. The numbers were damning. Black defendants in Bascom's courtroom were 2.3 times more likely to have their charges elevated than white defendants with similar profiles. They received fines that were, on average, 47% higher. Their hearings lasted less than half as long. These are not anomalies, Fitch said. These are not statistical flukes. Over 5 years and more than 4,000 cases, the pattern is consistent, pervasive, and unmistakable. Bascom's attorney objected. Statistics can be manipulated to show anything. The respondent processed a high volume of cases with limited resources. Efficiency should not be confused with bias. Forsyth looked at Fitch. Your response? The statistics are drawn from the court's own records, which were authenticated by county IT officials. We're not manipulating anything. We're reading what's already there. Objection overruled. Continue. Fitch moved to the complaint history. 47 complaints in 5 years. She read excerpts from a dozen of them. Handwritten letters from defendants describing hearings that lasted seconds. Explanations that were cut off. Requests for clarification that were met with contempt charges. Each of these complaints was dismissed without investigation, Fitch said. Not because they lacked merit, but because the system designed to review them was controlled by the same people who were being complained about. She pulled up a document. This is an internal memorandum from the Marbury County Clerk's Office, dated March 2022. It instructs staff to, and I'm quoting directly, file JQC complaint forms in the auxiliary storage room and advise complainants that the office is not responsible for forwarding such documents. She let that sink in. In other words, the courthouse was systematically preventing complaints from reaching the commission that was supposed to review them. Bascom's attorney rose again. The respondent had no knowledge of this memorandum. Clerk's office procedures are not within the judge's direct control. The memorandum was signed by Ramona Whitford, Fitch replied. Ms. Whitford reported directly to Judge Bascom for all administrative matters. The chain of command is clear. Forsyth made a note. Continue. The bodycam footage was next. Fitch had debated whether to show it. The recording was incomplete. The 10-minute gap remained, and Garvey's attorneys had already argued that any footage should be excluded as unreliable. But the footage that did exist was powerful. She pressed play. The screen showed the interior of Bascom's courtroom. The timestamp read 15:31:47. Coretta Vance stood in the gallery, folio in hand. I'd like to invoke the public comment period under Rule 2.215. Bascom's voice, off camera. You have 60 seconds. Coretta began to speak, calm, measured, professional. I'm formally requesting the case number for filing a complaint regarding the proceedings in case 2024-TR-04417. Specifically, I'm concerned about the escalation of charges without apparent justification. That's enough. The bang of Bascom's hand on the bench was audible even through the recording's poor audio quality. Bailiff, remove this woman. She's in contempt of court. The camera angle shifted as Hodge moved toward Coretta, her voice still calm. I'm following the posted procedure, Your Honor. Hodge's hand closed around her arm. Ma'am, you need to come with me. I'm not resisting. I would like this interaction recorded. You don't get to decide what's recorded. The footage showed Hodge pulling Coretta toward the door. Her folio fell, papers scattered across the floor. Her voice again, steady despite everything. I'm not resisting. I request a supervisor. Then the door. Then the hallway. Then static. The 10-minute gap had begun. Fitch paused the recording. What you just saw was a citizen exercising a right explicitly guaranteed under Florida court rules. She was not disruptive. She was not threatening. She was not violent. She was asking a question. She turned to face the panel. For that, she was dragged from a courtroom, arrested, and held for 7 hours in a county detention facility. She was transported via a route that deviated from standard protocol for 15 minutes, a deviation that coincides exactly with the unexplained gap in Deputy Garvey's bodycam footage. And when she was finally released, she bore a visible injury that was not present when she entered custody. Fitch placed a photograph on the evidence table. The booking photo. Coretta Vance's face, captured under harsh fluorescent light. The bruise beneath her left eye was dark and unmistakable. This is what happens in Marbury County to people who ask questions. Bascom's attorney launched an aggressive cross-examination. Ms. Fitch, isn't it true that the individual in question, this Ms. Vance, had been warned multiple times to sit down before she was removed? She was told to sit down, yes, but the posted rules of the court gave her the right to speak during public comment. And isn't it true that Judge Bascom has the discretionary authority to maintain order in his own courtroom? Discretion has limits. When it's used to silence legitimate participation, it becomes abuse. Objection, argumentative. Overruled, Forsyth said. The witness may answer. Fitch met the attorney's eyes. Discretion has limits. That's my answer. The hearing continued for 3 days. Witnesses were called, documents were reviewed, arguments were made and rebutted. Bascom himself took the stand on the second day. His testimony was polished, clearly rehearsed with his attorneys. He spoke of his dedication to public service, his commitment to efficiency, his frustration with activists who sought to undermine the justice system. He denied any racial bias. He denied any knowledge of the complaint suppression memorandum. He denied ordering Coretta Vance's removal. He had merely requested that the bailiff restore order. When asked about the statistical disparities in his courtroom, he shrugged. I process the cases that come before me. I don't control who gets arrested. Fitch's cross-examination was brief but devastating. Judge Bascom, you testified that you process cases as they come to you. Is that correct? Yes? Then can you explain why, in case number 2024-TR-04417, the original citation for running a yellow light was elevated to reckless driving, a first-degree misdemeanor, without any documented evidence of reckless behavior? Bascom hesitated. The charges were determined by the state attorney's office. Actually, the charge sheet was signed by you. Your signature is on the bottom of the document. Fitch held up the paper. Do you recognize this? Bascom's face reddened. I sign many documents. And do you read them before you sign them? Silence. Judge Bascom, do you read the documents you sign? I rely on my staff to prepare accurate paperwork. So your testimony is that you signed a document elevating a traffic infraction to a criminal charge without reading it. I didn't say that. Then did you read it? Another silence, longer this time. I may have reviewed it briefly. And you found nothing unusual about a yellow light violation becoming reckless driving? Bascom's attorney objected. Counsel is badgering the witness. Withdrawn, Fitch said. I have no further questions. The panel deliberated for 4 hours. Those who waited in the gallery did so in near silence. Marcus Webb stared at the door, hands clasped in his lap. Shayla Vance checked her phone compulsively, as if the verdict might arrive by text. Coretta Vance sat perfectly still, folio closed, eyes forward. She had been in deliberation rooms before. She knew what those hours felt like, the weight of evidence, the parsing of arguments, the search for consensus. She did not try to predict the outcome. She simply waited. At 4:17 p.m., the panel returned. Judge Forsyth read from a prepared statement. The Judicial Qualifications Commission of Florida has reviewed the evidence presented regarding Respondent Orville. Raymond Bascom. After careful consideration, the panel finds as follows. She paused. The room held its breath. On the charge of failure to perform judicial duties impartially, the panel finds sufficient evidence to support a finding of violation. Marcus Webb exhaled. On the charge of failure to accord persons the right to be heard, the panel finds sufficient evidence to support a finding of violation. Shayla gripped the armrest of her chair. On the charge of conduct prejudicial to the administration of justice, the panel finds sufficient evidence to support a finding of violation. Coretta's pen moved across her notepad. On the charge of willful misconduct in office, the panel finds sufficient evidence to support a finding of violation. Forsyth looked up from her papers. It is the recommendation of this panel that Respondent Orville Raymond Bascom be suspended from judicial duties without pay, effective immediately, pending the completion of the Department of Justice investigation and further disciplinary proceedings. She struck the gavel. This hearing is adjourned. The courtroom erupted. Bascom's attorneys immediately began objecting, demanding clarification, threatening appeals. Reporters who had been sitting quietly in the back row rushed toward the exits, phones already raised. Marcus Webb sat frozen in his seat, tears streaming down his face. Shayla turned to find her aunt. Coretta was already standing. She walked toward the door without looking back. She did not smile. She did not speak to reporters. She simply walked, out of the hearing room, down the corridor, through the lobby, and into the Tallahassee afternoon. The fight was not over, but something had shifted. For the first time in 23 years, the machine had been forced to stop. The consent decree was signed 6 weeks later. The negotiations had been brutal. Marbury County's lawyers fought every provision, challenged every requirement, demanded exemptions and delays and phase-in periods. But in the end, faced with the threat of a federal lawsuit they could not win, they agreed. Department of Justice, United States versus Marbury County, Florida Consent Decree. The United States of America and Marbury County, Florida, hereby agree to the following terms. 1. The county shall implement mandatory bias training for all court personnel to be completed within 90 days. 2. All courtroom proceedings shall be recorded in their entirety. Gaps in recording shall trigger automatic review. 3. An independent monitor shall be appointed for a period of 18 months to oversee implementation of reforms. 4. The county shall establish a citizen complaint process with clear posted procedures and regular public reporting. 5. All charge escalations must be documented with specific factual justifications and reviewed by a supervisor before filing. 6. The county agrees to pay $2.4 million to establish a fund for individuals who were subjected to unconstitutional fines and fees. This agreement is entered into without admission of wrongdoing by any party. Without admission of wrongdoing. Coretta read that phrase 3 times. She was sitting in her study, the consent decree open on her laptop, the afternoon light filtering through the blinds. $2.5 million for thousands of victims. 18 months of monitoring for 23 years of abuse. Training sessions and procedural reforms for a system that had destroyed lives. It was not justice. It was not even close. But it was something. The individual outcomes were similarly incomplete. Judge Orville Bascom remained suspended pending further proceedings. His attorneys had filed appeals that would take months to resolve. He had not been removed from the bench, not yet. He continued to receive his pension. Bailiff Tyrell Hodge was transferred to administrative duties. He was no longer permitted to interact with the public. He had not been fired. Deputy Nash Garvey was placed on desk duty while an internal investigation reviewed the 10-minute bodycam gap. The investigation had been ongoing for 4 months. No conclusions had been reached. Clerk Ramona Whitford received a letter of counseling in her personnel file. She continued to work at the courthouse. Prosecutor Sterling Jessup had quietly resigned and taken a position at a private firm in Orlando. His departure was described in official communications as a career transition. The machine had been damaged, but it had not been destroyed. Why, this is the moment of truth. If you've made it this far, you're a real one. Hit subscribe and turn on notifications. You won't want to miss what comes next. 2 weeks after the consent decree was signed, Coretta Vance returned to work. The 11th Circuit Courthouse in Atlanta rose above Peachtree Street, its modernist facade reflecting the winter sun. She had walked through these doors thousands of times over 3 decades, first as a law clerk, then as an attorney, then as a judge. Today felt different. She passed through security, the same process she had undergone at Marbury County, but here no one asked her to open her folio. No one looked at her with suspicion. No one questioned her right to be present. She was Judge Vance here. Not a troublemaker, not a civilian, a judge. She took the elevator to the 4th floor and walked to her chambers. Her assistant, a young man named David, who had been with her for 3 years, looked up from his desk. "Good morning, Judge. Welcome back." "Thank you, David. What's on the docket?" He handed her a stack of files. 3 oral arguments this morning, the Hensley appeal, the Markham brief, and— he hesitated. "A new case that just came in from the Northern District of Florida." "What case?" David's face was carefully neutral. "It's an appeal from Marbury County." Coretta stopped. "What kind of appeal?" "Civil rights claim. Defendant alleges due process violations in a traffic court proceeding." He paused. The presiding judge was Orville Bascom. Coretta took the file. She opened it. The case number was 24-1847. The original proceeding had taken place on April 10, 2024, 5 days before her own arrest. The defendant was a young black man named Terrence Whitmore. The original charge was failure to yield at a stop sign. The final charge was reckless driving, evading arrest, and resisting a law enforcement officer. The sentencing judge was Orville Bascom. The arresting officer was Nash Garvey. Coretta sat in her chambers, staring at the file. She knew what she had to do. She picked up the phone. "This is Judge Vance. I need to recuse myself from case number 24-1847. The clerk on the other end paused. "May I ask the reason, Your Honor?" Coretta looked at the file. At the name of the judge who had ordered her removal. At the name of the deputy who had struck her. At the system that had protected them both for so long. "Conflict of interest," she said. She hung up. Then she opened the file again and began to read. The Terrence Whitmore case was a mirror of what had happened to Shayla. A minor infraction, an inexplicable escalation, a hearing that lasted less than 90 seconds. But Terrence's case had gone further. When he tried to explain that he had stopped at the sign, that Deputy Garvey's claim was false, Bascom had held him in contempt. When he continued to protest, Hodge had removed him from the courtroom. When he resisted, pulling his arm away from Hodge's grip, Garvey had tackled him in the hallway. Terrence Whitmore was 18 years old. He had graduated high school 3 months before his arrest. He had been planning to attend community college in the fall. Instead, he spent 9 months in county jail, awaiting trial on charges that eventually resulted in a plea deal, 2 years probation, a $1,000 fine, and a felony record that would follow him for the rest of his life. The appeal argued that his constitutional rights had been violated at every stage, from the initial stop through the sentencing. It cited Bascom's pattern of bias. It cited Garvey's history of excessive force. It cited the systematic suppression of complaints. And it cited, in a footnote, the case of Coretta Vance. She could not preside over this case, but she could do something else. She picked up the phone again. "David, I need you to pull something from the archives." "What do you need, Judge?" "Every appeal from Marbury County over the last 5 years. Every case that involved Orville Bascom, Nash Garvey, or Tyrell Hodge." A pause. "All of them?" "All of them." There were 47 cases, 47 appeals from Marbury County that had reached the 11th Circuit since 2019. 41 had been denied without oral argument. 4 had been dismissed on procedural grounds. 2 had been reversed on narrow technical issues that did not address the underlying conduct. None, not one, had resulted in a finding of systematic misconduct. Coretta reviewed each file. She saw the pattern that had been invisible before: defendants who could not afford private attorneys, public defenders who were overworked and underfunded, briefs that were filed late or incomplete, arguments that failed to cite the right precedents or raise the right issues. The system had worked exactly as designed. It had filtered out the weak cases, the poorly argued cases, the cases where injustice was obvious but procedurally unreviewable, and it had allowed the strong cases, the cases that might have exposed the rot, to slip through the cracks. Coretta closed the last file. It was past midnight. Her chambers were dark except for the lamp on her desk. She thought about Marcus Webb, still paying off a $200 fine in $20 installments. She thought about Terrence Whitmore, 18 years old with a felony record. She thought about every face in that courtroom gallery, the people who had looked down at their hands, who had not dared to speak, who had accepted whatever Bascom decreed because they believed they had no other choice. And she thought about herself, a federal judge with 3 decades of experience, with resources and connections, and the full weight of the judicial system behind her. Even she had been arrested. Even she had been struck. Even she had been silenced. Temporarily, incompletely, but silenced nonetheless. What chance did anyone else have? She began to write. Not a legal brief, not a judicial opinion, a letter. To the Chief Judge of the 11th Circuit, I am writing to request a systematic review of all appeals originating from Marbury County, Florida, for the period of 2015 to present. Recent investigations by the Department of Justice and the Florida Judicial Qualifications Commission have established a pattern of civil rights violations in the Marbury County court system. These findings raise serious questions about the integrity of proceedings in that jurisdiction, questions that may affect cases previously reviewed or dismissed by this court. I recognize that reopening closed matters is an extraordinary step, but the evidence suggests that an extraordinary response is warranted. I am personally recused from any case involving Judge Orville Bascom, Deputy Nash Garvey, or other officials implicated in the federal investigation. However, I believe the court has an obligation to ensure that defendants from Marbury County receive the due process protections guaranteed by the Constitution. I am requesting that the court appoint a special panel to review these matters and determine whether any cases warrant reconsideration. Respectfully, Coretta A. Vance, Judge, United States Court of Appeals for the 11th Circuit. She sent the letter at 1:15 a.m. Then she drove home. The streets of Atlanta were empty at that hour. The city lights reflected off wet pavement. It had rained while she was working, and she had not noticed. She pulled into her driveway, walked into her house, sat down at the kitchen table, and finally, for the first time since that day in Marbury County, she allowed herself to feel it. The rage, the grief, the exhaustion. She put her head in her hands, and she wept. The response came 3 days later. The chief judge approved her request. A special panel of 3 judges, none of them connected to any Marbury County case, would review the 47 appeals. The review would take months, possibly years. It would require resources the court could barely spare. But it would happen. And if the panel found what Coretta believed they would find, patterns of injustice, violations of rights, defendants who had been failed by a system that was supposed to protect them, then something might change. Not everything, not overnight, but something. The envelope arrived on a Wednesday. No return address. Postmark from Marbury County. Coretta held it for a long moment before opening it. Inside was a single sheet of white paper, handwritten, neat, careful letters. Thank you. You said what we couldn't. M.W. Marcus Webb. She read the note 3 times. Then she folded it carefully and placed it in her leather folio, between the blank pages she had not yet filled. There is a coda to this story. It takes place 18 months after the consent decree was signed. The Federal Monitor filed her final report. Marbury County had implemented most of the required reforms. Bias training had been completed. Recording systems had been installed. The citizen complaint process was functional, if underutilized. But the report also noted concerns. Compliance was uneven. Some personnel had embraced the changes, others had resisted. The independent monitor recommended extending her oversight for an additional 12 months, but the county objected, and the DOJ, stretched thin by investigations in a dozen other jurisdictions, declined to push the issue. The consent decree expired on schedule. Marbury County was, officially, reformed. On the day the consent decree ended, a new judge took the bench in room 104. Her name was Patricia Caldwell. She was 54 years old, a former public defender, the first black woman to serve as a judge in Marbury County history. Her first act was to remove the plastic sign that had hung behind Bascom's chair, the one that promised all persons the right to be heard. She replaced it with something larger, a banner stretched across the entire back wall. It read, "Justice is not a privilege, it is a right." The words were visible from every seat in the gallery. Judge Bascom never returned to the bench. His appeals were denied. His suspension became permanent. He retired to a house in the Florida Panhandle, where he lived on his pension and occasionally wrote letters to the editor complaining about activist judges and federal overreach. He never admitted wrongdoing. He never apologized. He simply faded away. Deputy Nash Garvey resigned before the internal investigation concluded. He moved to Alabama and applied for a position with the sheriff's department there. The application was denied. Someone had forwarded the DOJ findings to the hiring committee. Last anyone heard, he was working as a security guard at a warehouse outside Mobile. Bailiff Tyrell Hodge retired with full benefits. He told friends he was glad to be done with the circus. No charges were ever filed against him. Clerk Ramona Whitford was promoted. She became the senior administrative officer for the new judge. Some things do not change. Shayla Vance graduated from community college with an associate degree in paralegal studies. She took a job at a legal aid clinic in Jacksonville. On her first day, she helped a client file a motion to withdraw a plea that had been coerced. The motion was granted. Marcus Webb paid off his fine 3 months after the consent decree was signed. He used the money from the Victim Compensation Fund, $1,847, his share of the settlement. He used the rest to repair his grandmother's Honda Civic. He still drives it to work every day. And Coretta Vance? She continued to serve on the 11th Circuit. She continued to review appeals, write opinions, shape the law in ways large and small. But something had changed. She thought differently now about the cases that came before her, about the defendants whose names appeared in briefs, reduced to case numbers and procedural histories, about the gap between what the law promised and what the law delivered. She could not fix everything. She could not fix most things. But she could pay attention. She could ask questions. She could remember what it felt like to be on the other side of the bench. The last page of her folio remained blank for a long time. Then one evening, she wrote something on it. A note to herself. A reminder. The system is not broken. It works exactly as designed. The question is, designed for whom? She closed the folio, set it on her desk, and went back to work. There is one more thing. The email chain that Lenora Fitch discovered, the one that led to the Shell Corporation, the law firm, the state representative, was never fully explained. Warren Delacroix denied any involvement. His attorneys successfully blocked further investigation by invoking legislative privilege. The federal investigation was closed without charges. The redacted sender was never identified. The question remained, who had known that Coretta Vance was coming? Who had given the order? Who had said, if she shows up again, handle it? On the anniversary of her arrest, Coretta received another envelope. This one was different, thick manila.
No return address. Postmark from Tallahassee. Inside was a single document. A printout of an email. Unredacted. From w.delacroix@.gov to o.bascom@marburycounty.gov. Date April 14th, 2024. Subject: Tomorrow's docket. Orville. There's a woman asking questions about the Vance case. Older, black, showed up at the clerk's office requesting complaint forms. Someone said she might be connected to the family. Be careful. We don't need any more attention on the traffic program right now. The revenue numbers are already under scrutiny. If she shows up again, handle it. W. Coretta stared at the email. Proof. Real, undeniable proof. She could take this to the DOJ. She could reopen the investigation. She stopped, looked at the postmark again. Tallahassee. Someone on the inside had sent this. Someone who wanted the truth to come out. Someone who was willing to risk everything to make sure it did. Coretta placed the email in her folio. Then she picked up the phone. David, I need you to set up a meeting with the U.S. Attorney for the Northern District of Florida. A pause. When, Judge? Coretta looked out her window. At the city, at the courthouse, at the system that had tried to silence her and failed. Tomorrow. The machine was still running, but so was she. The U.S. Attorney's Office for the Northern District of Florida occupied the 6th floor of a federal building in Tallahassee that smelled of old carpet and fresh ambition. Coretta arrived at 8:45 a.m., 15 minutes early. She carried her leather folio. Inside was the email. The receptionist, a young woman with sharp eyes and a security clearance badge, looked up as Coretta approached the desk. Judge Vance, they're expecting you in conference room C. She was escorted down a corridor lined with photographs of previous U.S. attorneys, their faces frozen in expressions of practiced authority. At the end of the hall, a door stood open. Inside, 3 people waited. U.S. Attorney Raymond Castellanos sat at the head of the table, a man in his early 60s with silver hair and the weathered look of someone who had spent decades fighting battles that never quite ended. To his left sat a woman Coretta recognized, Elena Ruiz, the DOJ Civil Rights Division attorney who had overseen the Marbury County investigation. To his right sat a younger man in a dark suit, introduced as Special Agent Marcus Holt of the FBI's Public Corruption Unit. Coretta took the empty seat across from them. Thank you for coming, Judge. Castellanos' voice was measured. I understand you have something to show us. She opened her folio, removed the email, slid it across the table. Castellanos read it once, then again. His expression did not change, but something shifted behind his eyes. Where did you get this? It arrived at my home. No return address. Postmark from Tallahassee. Do you know who sent it? No. Ruiz leaned forward to read the email. Her reaction was less controlled. Her jaw tightened,
and she exchanged a glance with Agent Holt. "This is the unredacted version," she said. "We requested this during the original investigation." Delacroix's attorneys claimed legislative privilege. The court agreed. Someone disagreed with that decision. Coretta's voice was calm. Someone with access to the original file. Agent Holt spoke for the first time. "Judge Vance, I need to ask you something directly. Are you prepared to cooperate with a federal investigation into State Representative Warren Delacroix?" Coretta met his eyes. "I'm prepared to do whatever is necessary to ensure that the people responsible for what happened in Marbury County are held accountable. All of them." Castellanos nodded slowly. "Then let's begin." The investigation that followed was unlike anything Coretta had experienced. As a judge, she was accustomed to receiving information, carefully curated, procedurally filtered, presented by attorneys who had already done the work of investigation and analysis. Now she was part of the process. Agent Holt's team interviewed her 3 times over the following weeks. They asked about her arrest, about the transport deviation, about every interaction she had witnessed in the Marbury County courthouse. They asked about the email. They asked who might have sent it. They asked if she had any enemies who might be trying to set her up. "Set me up for what?" she asked. Holt's expression was grim. "Delacroix has powerful friends. If he learns you're cooperating with this investigation, he'll try to discredit you. We need to be prepared for that. I've been discredited before." Coretta thought of the booking photo, the bruise beneath her eye, the hours in the holding cell. "I survived. This will be different. This will be political." She did not flinch. "Then let it be political." If you're still here, you already know this channel delivers. Subscribe now and hit the bell. The next part is going to blow your mind. The first attack came 2 weeks later. A story appeared on a conservative news website, headlined, "Activist Judge Targets Republican Lawmaker in Partisan Witch Hunt." The article described Coretta as a liberal judicial activist who had been arrested for disrupting court proceedings and was now seeking revenge against a state representative who had no connection to the original case. It quoted unnamed sources who described her as unstable and obsessed with perceived racial grievances. It did not mention the DOJ investigation. It did not mention the consent decree. It did not mention the 47 complaints or the statistical evidence of bias. Coretta read the article in her chambers, coffee growing cold beside her. David appeared in the doorway. "Judge, there are reporters calling. A lot of them." "I'm not speaking to reporters. They're asking about the Delacroix investigation. Somehow it leaked." She closed her laptop. "It didn't leak. It was released, strategically, to change the narrative." David hesitated. "What do you want me to do?" "Nothing. We stay silent. We let the investigation speak for itself." She returned to her work, but the attacks did not stop. Over the following weeks, the campaign intensified. Radio hosts questioned her impartiality. Bloggers dug into her past cases, looking for anything that could be framed as bias. An anonymous complaint was filed with the 11th Circuit, alleging that she had prejudged the Marbury County appeals, a complaint that was quickly dismissed but generated another round of headlines. Warren Delacroix himself appeared on a cable news program, his silver hair perfectly styled, his voice smooth with practiced outrage. "This is a political persecution," he said. "A federal judge is using her position to target a duly elected representative of the people. It's an abuse of power, plain and simple." The interviewer nodded sympathetically. "And what about the allegations in Marbury County? The DOJ investigation?" Delacroix waved his hand dismissively. "That investigation found no criminal wrongdoing. A consent decree is not an admission of guilt, it's a settlement. The county agreed to make some procedural changes to avoid the cost of litigation. That's all." "But what about the email? The one that allegedly links you to Judge Bascom?" Delacroix's smile tightened. "I have no knowledge of any such email, and I would remind you that publishing unverified documents obtained through illegal means is itself a crime." The interview ended, but the threat was clear. The next attack was more direct. Coretta returned home one evening to find her mailbox open, its contents scattered across the lawn. She gathered the letters, bills, advertisements, a newsletter from the Bar Association, and noticed that one envelope had been opened. Inside was a photograph of her house, taken from the street. At night, there was no note, no message, just the image. She stood in her driveway, holding the photograph, feeling something she had not felt since that day in the courthouse hallway. Fear, real, physical fear. She went inside, locked every door, called Agent Holt. "We're taking this seriously." Holt's voice was tense. "I'm arranging protection." "I don't need protection. I need this investigation to move forward. It is moving forward, but Delacroix knows we're getting close. This is how people like him operate. They try to intimidate witnesses, slow things down, create doubt. I'm not a witness, I'm a judge. Right now, you're both. A pause. Judge Vance, I need you to be careful. These people don't play by the rules. They've already shown what they're willing to do. She thought of Garvey's hand on her arm, of the 10 minutes that disappeared from the body cam, of the bruise that bloomed in the booking photo. I know exactly what they're willing to do. The protection came in the form of 2 U.S. Marshals who parked outside her house in rotating shifts. Coretta did not speak to them. She did not invite them inside. She simply acknowledged their presence and continued her life. She went to work. She reviewed cases. She wrote opinions. And every night, she came home to a house that no longer felt safe. 3 weeks after the photograph arrived, Agent Holt called with news. We found the source of the leak. Coretta sat up straighter in her chair. Who? A staffer in Delacroix's office. Young woman named Priya Sharma. She's been there for 3 years, working on Judiciary Committee matters. Why would she leak the email? Because she saw what was happening and couldn't live with it. Holt's voice carried a note of something that might have been admiration. She's agreed to cooperate, fully. Coretta closed her eyes. Someone on the inside. Someone willing to risk everything. Is she safe? We've moved her to a secure location. Delacroix doesn't know she's the source. Not yet. What does she have? More than the email. She has records of payments from court-related revenue streams that were funneled through a passee controlled by Delacroix. She has correspondence showing he personally intervened to block judicial appointments that might have threatened the arrangement. And she has testimony about meetings where the traffic program was discussed explicitly. The traffic program. The machine. When can I see her statement? You can't. Not yet. You're recused from any case involving Marbury County, remember? This isn't about Marbury County anymore. This is about corruption at the state level. Which is exactly why you need to stay at arm's length. Holt's voice softened slightly. Judge, I know this is frustrating, but if you're too involved, Delacroix's lawyers will argue that the entire investigation is tainted. We need this to be clean. She understood. She hated it. But she understood. What happens next? We present the evidence to a grand jury. If they indict, Delacroix goes to trial. How long? Weeks. Maybe a month. And in the meantime? In the meantime, we watch, we wait, and we make sure nothing happens to you or Ms. Sharma. The grand jury convened in early March. Coretta was not present, could not be present, but she followed the proceedings through Holt's carefully worded updates. Day 1. Presentation of financial records showing irregular payments from Marbury County to a political action committee. Day 2. Testimony from former court employees describing pressure to meet revenue targets. Day 3. Analysis of the email chain, authenticated by FBI forensic specialists. Day 4. Priya Sharma took the stand. Her testimony lasted 6 hours. She described meetings where Delacroix discussed the traffic program as a reliable source of campaign funding. She described his reaction when the DOJ investigation was announced, the frantic phone calls, the shredding of documents, the threats against anyone who might cooperate. She described the email she had copied before it was deleted, and she described why she had finally come forward. I couldn't sleep anymore. Every time I closed my eyes, I saw the faces of the people who went through that courthouse. The people whose lives were destroyed so that a few politicians could stay in power. Her voice, according to Holt, was steady throughout. I decided I'd rather lose my career than lose my soul. We're in the final stretch. If this story hit different, leave a comment below and share it with someone who needs to hear it. The indictment came on a Thursday. United States versus Warren Delacroix. 14 counts. Conspiracy to violate civil rights under 18 U.S.C. Section 241. Wire fraud. Honest services fraud. Obstruction of justice. The maximum sentence, if convicted on all counts, was 47 years. Delacroix was arrested at his home in Tallahassee at 6 a.m. The media was waiting. Someone had tipped them off, and cameras captured the moment the former chairman of the House Judiciary Committee was led to a federal vehicle in handcuffs. His attorneys immediately held a press conference. This is a politically motivated prosecution driven by a rogue judge with a personal vendetta. My client is innocent, and we will prove that in court. The trial was scheduled for September. In the meantime, Delacroix was released on $2 million bail. He was ordered to surrender his passport. He was forbidden from contacting any witnesses. He was, technically, a free man. But the machine he had built was crumbling around him. The trial lasted 3 weeks. Coretta did not attend. She followed it through news reports, through Holt's updates, through the transcripts that were released each evening. The prosecution's case was methodical, devastating. Financial records showed that Marbury County's traffic program had generated over $4 million in revenue between 2019 and 2024, revenue that flowed through a complex network of accounts before arriving at Delacroix's campaign fund. Email correspondence showed that Delacroix had personally intervened to block the appointment of a reform-minded judge who had been recommended by the local bar association. Testimony from former court employees described a culture of fear and compliance. Anyone who questioned the system was transferred, demoted, or forced out. And Priya Sharma took the stand again, repeating her grand jury testimony for the public record. Under cross-examination, Delacroix's attorneys attacked her credibility, her motives, her loyalty. She did not waver. "I was loyal," she said. "Loyal to the oath I took when I became a public servant. Loyal to the Constitution, not to any individual." The defense called character witnesses, colleagues, constituents, fellow legislators who praised Delacroix's dedication to public service. They called experts who questioned the statistical analysis of the Marbury County data. They called procedural specialists who argued that Delacroix's involvement was too attenuated to constitute a crime. But they did not call Delacroix himself. He sat at the defense table throughout the trial, his face a mask of righteous indignation, and never took the stand. The jury deliberated for 4 days. On the morning of the 5th day, they returned a verdict: guilty on 11 of 14 counts, conspiracy to violate civil rights, wire fraud, honest services fraud. Not guilty on obstruction of justice. The jury found insufficient evidence that Delacroix had personally directed the destruction of documents. The courtroom erupted. Delacroix's face went pale. His attorneys immediately announced their intention to appeal. Sentencing was scheduled for December. In the interim, Delacroix remained free on bail. He resigned his seat in the state legislature. He was stripped of his committee assignments. He was, for all practical purposes, finished. But the question remained: what would the sentence be? The sentencing hearing took place on December 14th. Coretta was present this time, not as a participant, but as an observer, sitting in the back row of the federal courtroom in Tallahassee. She wore the same gray cardigan she had worn on the day this all began. The courtroom was packed. Marcus Webb was there, sitting 3 rows ahead of Coretta. Shayla was there, her paralegal badge clipped to her jacket. Priya Sharma was there, under the protection of 2 federal marshals. And in the front row, the families of people who had been ground up by the Marbury County machine, people whose names had never made the news, whose cases had never been appealed, whose lives had been quietly devastated by a system that treated them as revenue sources rather than human beings. Judge Helena Marchetti presided. She reviewed the pre-sentencing report. She heard arguments from both sides, and then she spoke. "Mr. Delacroix, please rise." Warren Delacroix stood. He was thinner than he had been at the start of the trial. His silver hair had dulled. His hands trembled slightly as he gripped the edge of the defense table. "You have been convicted of 11 federal crimes. Crimes that strike at the heart of our democratic system. Crimes that exploited the most vulnerable members of our society for personal and political gain." She paused. "The prosecution has recommended a sentence of 25 years. The defense has requested leniency, citing your years of public service and the absence of any prior criminal record." Another pause. "I have considered both positions carefully." The courtroom held its breath. "Warren Delacroix, I hereby sentence you to 18 years in federal prison." A gasp from the gallery. Delacroix swayed slightly. "You will also pay restitution in the amount of $2.7 million to the Victims' Compensation Fund. Upon release, you will be subject to 5 years of supervised probation, and you are permanently barred from holding any public office in the United States." She struck the gavel. "This court is adjourned." The marshals moved forward. Delacroix was handcuffed in the courtroom, the same indignity he had ordered for countless others. As he was led toward the door, he passed within 3 feet of Coretta Vance. Their eyes met. His were filled with something that might have been hatred. Hers were calm, steady, unafraid. He looked away first, and then he was gone. Outside the courthouse, the December air was cold and sharp. Coretta stood on the steps, watching the federal vehicle carry Delacroix away. Marcus Webb approached her. "Judge Vance." She turned. He was older than she remembered. The months of proceedings had aged him, as they had aged everyone involved. But there was something in his eyes that had not been there before. Hope. "I never got to thank you properly." His voice was rough. "For what you did. For standing up when nobody else would." "I didn't do anything special. I asked a question." Sometimes that's all it takes. He looked at the departing vehicle. Sometimes asking a question is the most dangerous thing you can do. She nodded. They stood in silence for a moment. Then Webb extended his hand. Coretta shook it. Take care of yourself, Mr. Webb. You too, Judge. He walked away. Coretta remained on the steps, watching the traffic pass, feeling the weight of everything that had happened and everything that remained undone. That evening, she returned to her study. The leather folio sat on her desk, worn and familiar. She opened it, removed a blank page, and wrote. There is no such thing as complete justice. There is only the accumulation of small victories, each one incomplete, each one imperfect, each one built on the wreckage of what came before. Warren Delacroix will spend 18 years in prison. His machine has been dismantled. The people who operated it have been exposed, scattered, diminished. But the system that allowed the machine to exist in the first place, the system of concentrated power, of unaccountable authority, of institutions that protect themselves at the expense of the people they are meant to serve, that system remains. It will adapt. It will find new hosts. It will continue. And so must we. The work is never finished. The fight is never won. All we can do is show up, ask questions, refuse to be silenced, and hope that somewhere, someone is watching. Someone who will do the same. She closed the folio, placed it on the shelf beside the others. 31 years of notes, observations, and the accumulated weight of a life spent in service to the law. Then she turned off the light and went to bed. 6 months later, Coretta Vance was nominated to the United States Supreme Court. The confirmation hearing lasted 5 days. Senators questioned her about her judicial philosophy, her past decisions, her temperament, and inevitably, they questioned her about Marbury County. Judge Vance, one senator asked, some have suggested that your personal experience in that courthouse makes you incapable of ruling impartially on matters involving law enforcement or judicial conduct. How do you respond? Coretta leaned into the microphone. Senator, I spent 7 hours in a holding cell for asking a question. I was struck by a law enforcement officer who believed no one would ever hold him accountable. I witnessed a system designed to extract money from people too poor to fight back. She paused. That experience did not make me incapable of impartiality. It made me incapable of looking away. The hearing room was silent. I believe in the rule of law. I have dedicated my entire career to upholding it, but the rule of law is not an abstraction. It is a promise. A promise that every person, regardless of their race, their wealth, or their status, will be treated with dignity and afforded the protections of the Constitution. She met the senator's eyes. That promise was broken in Marbury County, broken for decades, and no one in power seemed to care, until someone asked a question. Another pause. If confirmed, I will continue to ask questions. I will continue to expect answers. And I will continue to believe that justice, however imperfect, is worth fighting for. The vote was 53 to 47. Coretta Vance was confirmed as the 119th Justice of the United States Supreme Court, the first black woman from the Deep South to hold the position. On the day of her swearing in, she wore the same gray cardigan beneath her new robes. No one could see it, but she knew it was there, a reminder of where she had been, of who she had been, of the woman in the county courthouse who had committed the unforgivable sin of asking a question. The oath was administered by the Chief Justice on the steps of the Supreme Court building. Shayla Vance stood in the front row, tears streaming down her face. Marcus Webb stood beside her, holding a small American flag. And somewhere in the crowd, though Coretta would not learn this until later, Priya Sharma watched from a distance, smiling for the first time in months. I, Coretta Amelia Vance, do solemnly swear that I will administer justice without respect to persons, and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as Associate Justice of the Supreme Court of the United States. So help me God. She lowered her hand. The crowd erupted in applause, and Coretta Vance, Justice Vance, looked out at the nation she had sworn to serve. The work was not finished. It never would be. But today, in this moment, something had changed. Not everything, not enough, but something. That night, alone in her new chambers, she opened her leather folio one last time. She turned to the final page and wrote a single sentence. The machine is still running. So am I. In the years following Justice Vance's confirmation, the Supreme Court issued landmark rulings on qualified immunity, judicial accountability, and the rights of defendants in state court proceedings. None of these decisions mentioned Marbury County by name. But those who knew the story recognized its influence in every line. Marcus Webb completed his degree in social work and now runs a nonprofit providing legal assistance to traffic court defendants in rural Florida. Shayla Vance was promoted to senior paralegal at her legal aid clinic. She is currently applying to law school. Priya Sharma wrote a memoir about her experience, which became a bestseller and was adapted into a documentary. The Marbury County Courthouse was renamed the Patricia Caldwell Justice Center in 2027, and somewhere in a federal prison in Alabama, Warren Delacroix serves his sentence in the Administrative Segregation Unit. For his own protection, according to prison officials, he has 14 years remaining. He has filed 3 appeals. All have been denied. Meaning and lesson. Coretta Vance's story is not just about a wrongfully convicted federal judge. It's the story of thousands of anonymous people, Marcus Webb-like individuals, Terrence Whitmore-like individuals, who stand before the dock and are crushed by a machine designed to exploit them. The first lesson: silence doesn't protect you, it only protects the oppressor. 47 complaints in 5 years, all buried because no one dared to ask why. The second lesson: one question can change everything. Coretta didn't carry a gun. There was no army. She simply stood up and asked, why? That question brought down 23 years of corruption. The third lesson: justice is never perfect, but it's worth pursuing. Delacroix spent 18 years in prison, not 47. The system remains, but it has been exposed, and that's the first step. If you're watching this video, remember, you don't need to be a federal judge to make a difference. You just need the courage not to look away. Please share this story. Please subscribe to the channel. Please turn on notifications. And most importantly, when you see injustice, ask why. That's how the machine stops. One question at a time.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.